Great. Thanks, Abby. Hi, everybody. Thanks for joining us. I don't know how many of you were jumping here from the other ACEC webinar on the new vaccine mandates, but I know that they were running a little long. So we probably have people jumping on periodically here. But what we wanted to do was just have each of us introduce ourselves quickly, just so that we know who's here, what company you're from. I'll start. I'm Lisa Dolan with Niche Engineering. I am a co-chair of the ACEC of Massachusetts HR Forum. And I will pass this on to Layla, and then we'll just go down. I'll just read the names off as I have them right now in order of the participant list. They're kind of jumping around a little bit, but we'll start with Layla next. Layla, can you hear me?
Yes, so I lost power. I apologize. Oh, no. I'm doing this from my phone. I have no power right now. No. So I'm Layla Kihlain, and I handle human resources for City Point Partners. And we've had some challenges with hiring and recruiting and finding good candidates. And so we've, over the years, have increased more and more the number of foreign employees that we hire. And it's been a positive experience. And I've asked Ashley to present to us all the different options for visas, for work visas, for hiring foreigners. So that's it. If we could have everyone introduce themselves, can you lead, Lisa? Because I can't
go down the list. Katie Murphy, you are next on my list.
Of course I am. Hello. It's nice to see you, Lisa.
You too.
And thank you for calling me Katie. So my name comes up as Kathleen Murphy. I go by Katie Murphy. I am the Director of HR for GZA, Geoenvironmental. I've been with GZA for 7.5 years and a member of the council for most of those years. And I am interested today in learning what other people are doing with regard to the transition from OPT to H1. We are losing an employee because we didn't jump on the H1 right away when they still had time on their OPT. And I'm curious if that happens to other people.
Thanks. All right, next I have Allison Hunt. Hi, Allison. Oh, you're muted.
Sorry about that. Too many Zooms today. I can't keep up with what I'm doing here.
Yeah.
I'm Allison Hunt. I'm Director of Human Resources at BSE Group. I'm very interested in this topic because we currently have 3 or 4 employees that are very interested in sponsorship. One of them we have tried for 2 years to get an H-1B approved and have been unsuccessful. So very interested to hear what the options are.
Great, thanks. Next I have Angelique.
Hi, I'm Angelique Gerlach. I'm VP of HR for Patrick Engineering. And we've been fulfilling more requests these days for visas, and to the point that I think we're ready. We have to create some type of procedure around how to limit and how to budget accordingly. And so it's not just kind of opening the floodgates. So I'm interested to hear what others have done.
Great, thank you. Next I have Becky Williamson.
So I'm Becky Williamson with Jacobs. I am the secretary on the ACEC board and the board liaison to this committee. But I will say with regard to visas, this is something obviously we come across all the time at the company as we're trying to find and hire talent. So just interested in learning more.
Great, thanks. And then I have Dan. Dan, I don't know if you're speaking. It looks like it's on mute.
Hey, sorry about that. Hi, my name is Dan Moriarty. I'm an HR specialist at CDM Smith. Part of our role here is doing, managing our immigration program. And so I like to attend a lot of these meetings here, get some new tips, learn some things. And this is something that we're hearing quite frequently from our recruitment staff. And there's a lot of questions coming around the hiring of individuals and retaining individuals with visas. So I thought this would be an excellent topic to share the information with our talent acquisition team.
Great, thanks, Dan. Then I have Esme.
Hi, everyone. I'm calling from VHB and kind of just mirroring a lot of what everyone has said. I'm actually new to overseeing the immigration process here at VHB, so I've learned a lot kind of on the roll as we've gotten requests for different visas, but really just trying to understand the different types of visas and just a general, what are our current companies sponsoring at all levels? Are companies kind of reserving sponsorship for more senior roles? Just sort of general inquiries like that.
Okay, great, thank you. Jamie Stelmat.
Hi, this is Jamie Stelmat from Weston and Sampson. So I'm just here because I would like to learn more about the process and what we can do internally versus what we have our attorneys do, which is the majority of the process. So it's very costly, and wondering what we can do, I can do as part of the process versus what our attorneys can do, and just general information because I just started doing it and we're seeing more and more as the years go on. So thank you.
Great, thanks. All right, I have Jill Martin.
Hi there, I'm Joe Martin from Ty and Bond. I'm head of talent acquisition. In my last position, when I worked in Boston, I did a lot of work with visas, OPT visas, H-1Bs, O visas, TN1 visas, labor certifications. I did all of that in my last incarnation, and now at Ty and Bond, we've done a little bit of work with visas, but I just kind of want to see in general how people are deciding to work with attorneys and how often they're doing it, and if it's successful, if people are able to bring people on board that way. So thanks.
Great, thank you. Next I have Juan Bradley.
Hi, everyone. My name is Juan Bradley. I work at CDM Smith. I am the senior manager of HR operations here and overseeing the immigration side of the house. So I'd be interested to understand how people prioritize their visas and and actually even after that, moving them to the green card process.
Great. All right. Then I have Kelsey O'Connor.
Hi, I'm Kelsey, HR administrator at HMMH. We're doing a bunch of hiring right now, and this is coming up quite a bit. We just hired someone on OPT visa, so wondering if when we get started on looking at the visa and all that kind of stuff. So interested in any information you have about the visa process would be greatly helpful.
Great. All right, and then I have Lindsay Lazinski.
Hi, sorry. I am here today, similar to some other colleagues. We do some sponsorship for mid-level and senior positions. Prior to McMahon, I wasn't heavily involved in the immigration process. We do have a really good relationship with an immigration attorney, but just looking to learn more and learn from each other here. So
Great.
Thank you.
Great, thanks. Maggie Snape.
Hi everyone, Maggie Snape from Fussy and O'Neill. I don't have anything new to add. I'm here with everybody else, just really to learn more about what others are doing. And similar to Angelique, I'm starting to sort of look at more of a process than just doing visas and things as requested. So just interested to hear what everybody has to say. Thank you.
Great, thank you. And then I have Meg Olivastri. I'm not sure if I'm saying that correctly.
Yeah, that's correct. Hi, I'm Meg, HR manager for Fitzmyer and Tachi. Sorry, I jumped on kind of late, but in hearing the last few people, it's definitely very similar as to why I'm here. We just recently this year started sponsorship, and really all we've done is H-1B transfers right now. So I'm really just interested to hear what the full scope is, and especially for these people who eventually will be looking for a green card process, what that entails.
Great, thank you. Next, I have M. Maynard. I'm not sure the first name.
Hi, it's Maria Maynard. And similar to everybody else, looking to hear and learn about visa processing and how it works now. I did a lot of visa processing probably 20 years ago, and it's maybe even 25 years ago. And it was a very different process. It went very quickly. Yeah, you could get the paperwork filed and get information back. And now we're in the process of converting an H-1B to Tata and Howard and eventually a green card. And it's so slow. So is that normal? Is that what's happening? It's a different process. So yeah, just to learn from everybody in the group and what they know. Thank you.
Great, thank you. Next I have Ruth Ann.
Hi, I'm Ruth Ann Bowman. I'm with McFarland Johnson. I'm joining today. I've had very limited experience with visa sponsorships. We've had really just a couple of students that we brought on through the OPT and kind of moved through that process. As others have said, it's just a very long, drawn out process. So just trying to learn from others as far as what you do to help expedite it, and any outside services attorneys you use as well.
Great, thanks. And Sarah Dorado?
Yes, hi, I am with Alfred Benesh and Company, and like many of you here, interested in learning more about how the strategic approach each group is taking. We are looking at, we have done some sponsorship and some successful transition into H-1B status, and really looking at that from an EDI perspective, and perhaps where we didn't include that in options, but opening that up and then doing the cost benefit analysis.
Great, thank you. And we have Servino Luna.
Good afternoon. Same thing. I'm looking. My process occurred about 15 years ago, and it took a couple of years just to have the process for me to be able to come here. I don't know if there are significant changes, but at the time I have a sponsorship, technical consultants that bring me over here. Right now we have as a company, and look, we have people looking to apply, and I want to understand the process, what's the difficulties, how this can be done, and how long it takes to be done with applying with the new regulations.
Great. All right. Thank you. And then I have S. Melninson.
Hi, Susan Melanson. I am HR coordinator with Greenman Peterson. And for the same reason, just to learn more about the process. We have a few visa employees, and it would be nice just to learn more about it.
Terrific, thanks. And then finally, I guess we have Ashley, who is left. I don't know, Layla, did you want to introduce her? Layla might still be having issues with her power. So
No,
Ashley, I'll let you introduce yourself. Oh, there you are.
I'm here.
Okay.
Sorry, I am on my phone and I don't have all the capabilities technically to.
That's fine.
I can listen, watch, but I'm not sure how to do anything else. I apologize.
No worries. No worries. Ashley, why don't you introduce yourself?
Sure. So my name is Ashley Scoville. I am an associate attorney at Fragment Del Rey, Bernstein and Lowy. And I've been an attorney consulting employers and employees in the employment-based non-immigrant and immigrant visa options for a couple of years now. And I look forward to presenting, hopefully hitting on everyone's questions. I'll try to do the best I can. But if I don't happen to hit something that you guys would really like to know, feel free. I'm going to have a question and answer period at the end.
Great, thank you. I'm not sure, Abby, are you going to be running a presentation?
Ashley should be able to do it. She should be able to do it.
Thank you.
I do want to add that Ashley was very successful for us. We did 4 H-1B visas last year, and she was able to do all of them for us. We got approved for 4 different people.
Wow, nice. Yeah. Thank you so much, Layla. Let me go ahead and try to share my screen here. Hopefully that all works. No technical difficulties. So can everyone see my screen? Perfect. Okay, great. So like I said, my name is Ashley. I am an associate attorney at Fragment, and we're going to jump into a discussion about employment-based immigration options. So I just want to start with a brief overview. It sounds like a lot of you have experience sponsoring or some knowledge of the immigration system, but I'm going to do a very brief overview just to make sure everyone's well aware of all the basics. We're then going to move into a discussion of employment-based non-immigrant visa options with a special focus on those that are helpful for engineers. And then we're going to move into a discussion of the employer-sponsored green card process. Specifically, we're going to talk about the PERM process. Finally, I'm going to end with a discussion of legal fees, and we're going to have a Q&A at the end. So my presentation right now, I think is going to run about 45 to 50 minutes. I'll try to keep it as brief as possible to leave as much room for Q&A. But hopefully, with the way things are running, maybe about 15 minutes or so for questions. I am available until 4:30, so as long as you guys are available, I'll be here to answer any questions you guys have. So let's move into a brief discussion about immigration basics. So for those of you who don't know, most applications are filed and adjudicated by United States Citizenship and Immigration Services, otherwise known as USCIS. USCIS is a branch of the Department of Homeland Security, and they are responsible for adjudicating any and all applications regarding non-immigrants and immigrant visa status, as well as citizenship. So any application process, regardless of what it is going to start with an application with USCIS. And you'll see an example of a USCIS approval, otherwise known as a I-797 notice of action on the right. This is what a traditional approval notice looks like. If USCIS approves the case and the beneficiary is currently in the, is currently in the United States, no other action needs to be taken. However, if you are sponsoring someone who is currently abroad, there is a second step of the process, which is a visa stamping appointment. A visa stamping appointment is done at their local consulate. And what happens as a part of that process is USCIS will wire the approval, and it will be wired to the local consulate of the beneficiary's choosing. And the beneficiary will go in for a visa stamping interview. And at that interview, the consulate doesn't re-adjudicate the underlying application with USCIS, as USCIS has already done that. What they're really looking for is an admissibility determination. They are making sure that they are making the appropriate decision in taking that leap of faith of giving that person that visa to enter the United States. So let's just talk briefly about what admissibility is. So admissibility is simply whether the beneficiary is worthy of entry to enter the United States. As an immigration system, our premise is that it's a privilege to enter the United States. So we take certain steps in making sure that people are worthy of our leap of faith and making sure that we are choosing the best people to enter the United States in terms of they're not going to pose any public danger and that they're going to use that visa issued to them appropriately. So certain considerations that the consulate looks to is criminal history, any prior issued visas, any problems with overstaying or not properly using a priorly issued visa. And in addition, any sort of membership in any sort of concerning organizations, like a terrorist organization, for instance, that frequently does come up. So let's discuss the difference between visa and status, because this happens to come up a lot with a lot of my employers and employees. It tends to trip people up. So the USCIS approval, like the slide on the right, or on the previous slide on the right-hand side, the USCIS approval is what confers status or the ability to be here in the United States. And status either kickstarts at the time of the approval or upon the beneficiary's entry into the United States if they happen to be abroad at the time of the approval. A visa or a visa stamp, those two things are used interchangeably, is given pursuant to status obtained via USCIS. So in the case of a H-1B approval, if USCIS approves an H-1B, the person, the beneficiary, would go to a consulate for a visa stamping appointment, and they would be issued a visa stamp in the class of H-1B. On the right-hand side of my slide, you will see a visa issued to a Mr. Dogland in F1 visa status. However, in the example I was just giving of H-1B, on the right-hand side where it says class, that would instead say H-1B, not F1. So a visa is only needed by foreign nationals who need to enter the United States from abroad. This is why for your beneficiaries who you might be sponsoring who are currently outside the United States at the time of approval, need to have that second step of the process, which is that visa stamping appointment. And additionally, any of your employees who maybe happen to be in the United States at the time of approval, but would like to internationally travel there afterwards, will also need a visa stamp. A visa stamp is what authorizes someone's ability to enter the United States from abroad. So hypothetically, someone who remains in the United States with no plans to internationally travel never needs a visa because the status alone is all that they need. It confers the ability to be here in the United States. So in other words, everyone has a status, but not everyone is going to have a visa. Let's talk briefly about immigration authority. So authority and requirements for most visas are granted through the Immigration and Nationality Act, otherwise known as INA, various treaties that the US has with other countries abroad, and the Code of Federal Regulations, which is abbreviated CFR. So every visa and its requirements are defined in at least one of these sources. However, the problem comes that a lot of these definitions are very broad. So as an immigration attorney, what I primarily rely on in giving people advice is case decisions. Sometimes USCIS will publish case decisions. Additionally, there is an appeals board of USCIS. They issue and publish decisions that are binding upon USCIS, as well as my own prior experience about what's going to be a problem, what may not be a problem. So unfortunately, because these sources are very broad, we kind of rely on prior experience, which can be sometimes a hit or miss. What makes it more of a hit or miss is that officers are afforded a lot of discretion in making their determinations. This includes both USCIS officers and consular officers. So consular officers in particular, in making an admissibility determination, there's actually, there's no appeal of a consular officer's determination that you are not inadmissible. And additionally, USCIS, while there is an appeal board, the standard is rather high to prove that there was an error made. The reason being is that these officers are afforded a lot of discretion in determining whether or not someone is approvable. So that's just something to keep in mind when starting an immigration case. Typically, my prior experience is that if, my gut is right, if something's worked in the past, 9 times out of 10, it will work again. But I always make sure everyone's well aware that there is a lot of discretion that does play into it, which can sometimes add a little bit of uncertainty throughout the process. So let's discuss the difference between non-immigrant and immigrant visas. So non-immigrant visas grants temporary work authorization and ability to reside in the United States. So we have a list of non-immigrant visas on the right. These are those that we're going to be talking about today. The one exception to this is the F1 student visa. That's a little different. People who enter in F1 student status cannot work while they're studying, but they are afforded 2 different types of work authorization post-degree decree. So those are sometimes work authorization options that we'll discuss in a moment. In order to be approved for a non-immigrant visa, the foreign national frequently must show something called non-immigrant intent. An intent is temporarily to remain in the United States for that pre-approved purpose. So in order to show non-immigrant intent, frequently the foreign national will show ties to their home country, things like bank accounts, an address maintained abroad, family abroad, things of that sort that should suggest that they would not, they would still have the desire to return home after that pre-approved stay. There are, however, some non-immigrant employment-based visas that allow for something called dual intent. These are H-1Bs and L-1s. And dual intent allows someone to have both non-immigrant and immigrant intent. And I know that sounds a little strange. How could someone have both the intent to temporarily remain and the intent to permanently remain? And it usually goes something like this. Someone who is in an H-1B enters the United States. They have the temporary intent to remain in the United States pursuant to their pre-approval or their approval through USCIS. However, they also have it in their mind that they'd like to approve or apply for a green card in the next couple of years. So they can maintain both that non-immigrant and immigrant intent without a risk to their underlying H-1B status. It also allows for that person to apply for a green card during their non-immigrant stay without it being, without it affecting their eligibility for that non-immigrant stay. On the other hand, immigrant visas grant permanent ability to work and reside in the United States. This is otherwise known as legal permanent resident or green card. You'll hear those two words used interchangeably. They are synonymous. They mean the exact same thing. And you'll see an example of a legal permanent resident card on the right. There are in family and employment-based petition options, but for our discussion, we're only going to talk about one way to sponsor an employee via employment immigrant visa, which is PERM. So up here on this chart, I have laid out the distinctions between non-immigrants and immigrants, just so you have a reference of what both can do. So you'll notice that both have a driver's license and a social security card. In particular, we don't want to leave non-immigrants, especially if they have work authorization without an ability to get to work. So driver's licenses are allowed. However, they're frequently granted in much smaller increments. They're only granted for as long as they've been approved by USCIS. So that's typically 2 to 3 years. So it's not going to be your usual 10-year driver's license that immigrants or citizens would have. But the main difference between the two is that non-immigrants temporarily live in the United States for a pre-approved purpose, and any changes must be reported and pre-approved to USCIS before those changes can take place. So for instance, if you have someone who is in an F1 status and they'd like to obtain an H1B, they must file a change of status application, an H1B application to USCIS, which effectively notifies USCIS of their intent to change. And that application must be approved prior to them taking employment under H1B status. Additionally, in H1Bs and L1s, any major changes in employment, like change of employers, changes in work location, major changes in job duties must be reported to USCIS via an H1B amendment or a change of employer application. And there are some exceptions, but traditionally these need to be pre-approved before someone can start those changes. So non-immigrants are constantly informing USCIS of any changes in their work or study or their main intent in being here in the United States. However, immigrants, on the other hand, have the ability to permanently work or study in the United States without any restriction. So someone who has a green card can bounce around between different employers. They can maintain 3 different employers. They can have 2 part-time, one full-time. They can change between work or study as much as they want. And that is done without notifying USCIS. So no one has to be notified of any changes. It's done completely according to their will. So let's discuss briefly some non-immigrant visas. So I know there are a few people who mentioned F1 student visas and work authorization. This is otherwise known as optional practical training, OPT, And there are two forms of it that are provided after a student receives their degree. So as I said before, F1 students cannot work while they're in the process of completing their degree, while they are taking classes. However, they are afforded two opportunities to take work that is related to their degree in order to give them hands-on training in their fields. And the first is post-completion OPT. This is 1 year of work authorization in a field related to their degree. Additionally, there is also STEM OPT. STEM OPT is for those students who have STEM degrees. Engineering is included, and it provides an additional 2 years of work authorization. So this is in addition to the post-completion OPT. So if you have any students who are currently on post-completion OPT and they are coming near their expiration date, they do have the ability to apply for an additional 2-year extension, so 3 years in total of work authorization. So both forms of work authorization have some requirements. They both require full-time work. There's not the ability to work part-time. In fact, there's an hourly minimum requirement that each student must meet. Additionally, while I am, totally aware of OPT and, I know generally the ins and outs of the program, really the foreign student advisor at the student's university is going to be your go-to individual. The reason being is that they are more well aware of all the ins and outs, the requirements. They know the student personally and therefore can attest to whether or not that person is personally on an individual case-by-case basis eligible to take OPT. And additionally, they're going to be the person who authorizes the position. So if you offer a position to a student and they are on OPT, it needs to be pre-approved by the student's foreign student advisor. So that student will take that approval to their foreign student advisor, and that advisor will look over the position to make sure it's related to their degree field and issue that approval. If that position is approved as being related to their degree fields, the student will then apply, they'll file one form with USCIS, which essentially just asks USCIS to issue a work authorization card. The student must receive that work authorization card and have it in hand before they're able to start working, which unfortunately right now, USCIS is taking a very long time to adjudicate work authorization cards. There is unfortunately no way to expedite that process, but it's making the headlines right now. It's of everyone's concern how long people have to wait for their work authorization cards. There is an example of a work authorization card on the right. The only difference between this and one for a OPT student is under terms and conditions where it says none here, this will say post-completion or STEM OPT instead. So let's move into the H-1B visa. This is probably the most common visa that you have heard of. It's frequently in the news, and it's probably one of the most common visas that I work on in my daily practice. It's got to be the most common thing that comes up. An H-1B allows an employer allows employers to employ foreign nationals in specialty occupations. Specialty occupations are those that require at least a bachelor's degree in order to reasonably and effectively perform its job duties. Typical occupations include an accountant, a lawyer, doctor, and engineers, because for all of these positions, at least a bachelor's degree, if not higher for a lawyer and a doctor, is required in order to reasonably perform its job duties. Approvals are given in 3-year increments, and there are similar treaty-based visas. So for those of you who are struggling to get your H-1Bs through the lottery, which I'll discuss in a minute, the H-1B ones are great options, as well as the E3. H-1B ones are for Chile and Singapore nationals, and E3 are for Australian nationals. These are made pursuant to treaties that the US has with Chile and Singapore and Australia. And they very much function like H-1Bs. The requirements are very much the same. And when someone receives an H-1B1 or an E3, it very much functions like an H-1B. But there are some positives, which I'll get to in a minute. So there are several pros. It's a traditional transition visa for students. A lot of people go from F1 to H1B. That's got to be one of the most common things encountered in my practice. And the reason why is that it has a low evidentiary burden. For the H1B program, we only must show that a bachelor's degree is the minimum requirement and that the beneficiary has obtained at least a bachelor's degree or its foreign equivalent. This is relatively easy for an F1 student to meet, an F1 student who's here completing a bachelor's or a master's degree. They easily meet these requirements, and as such, there kind of exists a pipeline between F1 and H1B. Additionally, there's minimal paperwork involved in the H1B process. We start with a labor condition application, which is filed with the Department of Labor. Sometimes the Department of Labor does get involved in immigration options, essentially in effect to protect U.S. workers and the interests of U.S. workers. So the main requirement of the labor condition application is a posting requirement. Employers must post information about the job being offered to its U.S. employees. That way they're aware that the employer is intending to hire a foreign national. And then that all culminates into an H-1B application, which is filed with USCIS. To give you a brief timeline, this is typically running 4 to 6 months, sometimes 6 to 8 months, depending on the time of year in order to process those. However, there is a premium processing option, which is available. Premium processing guarantees a decision within 14 calendar days of receiving the application. So there is a hefty fee associated with that, which I'll get to in a minute. But for those who feel or have a need to rush, especially when you're filing a change of employer application or just reassurance, having a quick decision may be reassuring to a lot of people. That is an option as well to kind of speed up the process. H-1Bs are one of our dual intent visas, which makes the transition from H-1B to a green card relatively smooth. The H-1B worker can apply for a green card without affecting their ability to extend their H-1B, which is great. Next, let's move into some cons. I heard a few of you mention the H-1B lottery, which is an unfortunate reality that we deal with on an annual basis. So per statute, there are only 65,000 visas made available each year for H-1B. There's an additional 20,000 made available for those with a master's degree or higher. This is known as a master's cap. But 85,000 visas is not nearly enough to cover the amount of applications that are received on an annual basis. So USCIS has instituted an annual lottery, which takes place every March. So what that looks like is it's a very brief application with very minimal details about the beneficiary, no details about the job offered. And USCIS will randomly select 85,000 visas. There's unfortunately no way of improving your chances of being selected in the lottery. The best recommendation I have is for those who are on F1 OPT, you start that H-1B lottery as soon as possible to give them as many chances at the bite of the apple, or as many bites of the apple as possible. That's really the only unfortunate way to, or really the only way, unfortunately, to increase chances is just applying over and over again. To give you an idea of the high demand, for fiscal year 2022, this was this year's lottery, and that took place in March, 274,000 applications were received for 85,000 spots. So the ratio is not good. Like I said, it is randomized, which is good. People do not have an unfair advantage over each other. But sometimes that means that unfortunately we do have some people who apply in the lottery and never get chosen. So hopefully some of these other options I'll talk about in a minute might be helpful. Additionally, the baseline filing fees for H-1B is rather high. They initially run at $1,710 to $200 or $2,460, and that depends on the size of the company. And then there is an additional $2,500 fee for premium processing. So for those of you who would like to pursue premium processing, it usually is available during CAP season. It's always available for those who are applying for a change of employer or an extension. So that's always nice, you know, for reassuring purposes, but it does come with a hefty price tag. Finally, there is a 6-year maximum stay on the H-1B. So people get one extension. So they get their initial for 3 years and an additional 1-year extension. The 6-year maximum stay, though, is not hard. If someone starts a green card process prior to entering into their 6th year on their H-1B, they can continuously renew their H-1B until they have a green card in hand. So that is nice. That's a good perk of the H-1B, and that's one of the reasons why the transition from H-1B to green card is traditionally very kind of without hiccups. The reason being is we don't have to worry about H-1Bs going out of status or not having their underlying status available to them while they're waiting for that green card process to go through. Next is the L1 intercompany transferee. An L1 allows a U.S. employer to transfer executive or managers or workers with specialized knowledge from one of its affiliated foreign offices. So this is primarily geared toward larger companies that have foreign offices abroad. For a smaller local company, this unfortunately is not going to be an option. The L1A is for those who are executive or managers. Manager is typically defined as one who manages people. However, USCIS has recognized something called a functional manager. Functional manager is one who oversees or otherwise helps along an essential function of the business. So they manage an essential function. However, in recent years, USCIS has kind of tried to push back on the functional manager because they don't actually manage people. But, you know, I have had some success with functional managers in the past. They can be applied for, especially in a relatively good case that is still an option. Next is the L1B, which is our specialized knowledge. For someone who wants to apply for an L1B, the U.S. petitioning employer must show that they will perform a position that requires specialized knowledge relating to the organization's interests. In my experience, this is typically company products or software. That tends to be probably the most common thing that comes up as specialized knowledge. Frequently, these jobs are sales executive or technical specialists who either sell products by traveling around to different company sites, performing maintenance, putting on presentations about the company's products or software. That is usually successful for an L1B. I've had success with those in the past. However, it does require a lot of experience. Typically, my L1Bs at least have 5 to 10 years of experience with the company and with their products or software. In addition to the requirements of executive or managerial or specialized knowledge, the beneficiary also must have employment for at least 1 year overseas in a qualifying organization. Qualifying organization is a reference to an affiliated foreign office. And what qualifies as an affiliated foreign office is one that is a parent company, a branch, a subsidiary, or an affiliate. And approvals like the H-1Bs are given out for 3 years. There are several pros. There's no cap on the number of L1s, so there's no lottery. So anyone who wants to apply can apply. Filing fees typically run much lower than the H-1B. It's typically hovering around $960 for an initial application, and there is premium processing made available. And L1s are another one of our dual intent visas, so they can apply for a green card without hurting their ability to continue their L1 status during their stay. However, there are several cons. For someone like an F1 student or someone who's already here in the United States and another non-immigrant stay, the L1 is not really going to be a good option for them, or at least the most desirable option for them. The reason why is it requires 1 year of employment abroad. So someone who's trying to stay here in the United States that doesn't want to go back overseas, the L1 would require them to do exactly that, which makes it in some instances very undesirable. Additionally, the requirements may be difficult for a student or otherwise unexperienced worker. For a student, they're typically taking entry-level positions, which are not typically going to be executive or managerial, or be one that you can show extensive specialized knowledge is required. Especially for a student who's taking an initial job, they're not going to have the number of years of experience that are helpful in showing specialized knowledge. Additionally, there are maximum stays. There's a 7-year maximum stay for L1As and a 5-year maximum stay for L1Bs. Unlike the H-1B, these are hard caps. So if you want to start a green card process for someone in L1 status, it must be started at least 2 years before. Typically the green card, the perm process takes about 2 years. So we really want to make sure we start in advance. That way we are not rushing towards the end to make sure that their non-immigrant L1 status goes out before they have a green card. So unfortunately, there's no ability to start a green card and be able to continuously renew beyond those caps. Those are hard limits. Next is the O1. Just as a kind of disclaimer, this is probably going to be the least common one that does come up, but sometimes it can be helpful for those who the L1 and the H-1B is not going to be a good fit. The O1A is for workers who possess extraordinary ability in sciences, education, business, or athletics. And just like the H-1B and the L1, approvals are given out in 3-year increments. The requirements, as you can probably tell by the slide, are incredibly difficult to meet. A beneficiary must at least have a Nobel Prize or at least at least 3 of the following. Just to give you an idea of the frequent ones that come up in my practice, membership in organizations or associations. Those associations must require outstanding achievement in order to be a member. Participation as the judge of the work of others in the fields, original scientific related contributions to the field, and authorship of published scholarly articles frequently do come up. There are several pros. Out of probably all the visas that you could apply for at USCIS, it has the lowest fee. It's right around $460. Premium processing is available as well. There is no annual cap, unlike our H-1Bs, so that also is a plus. And there is no maximum stay. This is one of the great benefits of the O1. Hypothetically, as long as the beneficiary continues to meet the requirements of the O1, they can continuously keep on extending in 3-year increments, hypothetically indefinitely, as long as they continue to meet those requirements. There are several cons, however. Out of all the visas you could possibly apply for, it's got to have one of the highest evidentiary burdens. Plentiful documentation is required. So for example, for our commonly used factors, for instance, like published scholarly articles, we submit every page of every single article that someone has written. So if you take, maybe about 30, 40 pages each article, times that by 5, that's at least 200 pages right there, just for one of the factors. Additionally, serving as the judge of the work of others, we show every instance that they have renewed or reviewed someone's prior work, served as the judge of a competition, any sort of documentation that is required in every single instance that they served as a judge. So that documentation adds up really quickly. In my experience, O1s have been the largest applications I've ever submitted. They're stacks high, which means a lot of analysis and a lot of time is taken to make sure that the beneficiary meets the requirements that we've done so effectively before we file. O1s are really only for those who are on the top of their field, and unfortunately students are unlikely to qualify. In my experience, I've even had students who work in very niche areas of fields, very successful. They might be in PhD or master's programs studying very unique things. We had reasonable arguments for all 3 of the factors, but USCIS utilized its discretion and said, we just cannot find that a student has extraordinary ability because they're simply a student, they're fresh. So USCIS did not dispute our arguments about each of the 3 factors. They just simply said, listen, we just cannot believe that this person has extraordinary ability. Finally, O1s do not have dual intent, which makes applying for a green card not impossible, but tricky. So the problem that comes up with non-dual intent visas is they cannot have a certain portion of the green card process impending or currently filed at the time that they file for renewal of their O1, or else that O1 is going to be denied on the basis of not having non-immigrant intent. So it's not impossible, but the timing has to be done just right. I frequently recommend that someone work with an immigration attorney of your choice to make sure that the timing is done just right, to make sure that this person does not run out of their O1 status or otherwise does not encounter any problems with accusations of fraud or whatnot. But the timing can be done appropriately. Finally is the TN visa. These are useful, handy visas that people typically do not think of, but they are rather limited. So authority for TN visas are provided pursuant to NAFTA, the North American Free Trade Agreement. NAFTA no longer exists. It's now the USMCA, US Mexico Canada Agreement, which was instituted by President Donald Trump in 2018. However, the requirements for the TN visa remained virtually the same under NAFTA and USMCA, so there hasn't been any change in that regard. The TN visa allows citizens of Canada and Mexico to work in the United States in pre-arranged business activities for foreign or US employers. So hypothetically, a TN visa holder could be working for a foreign employer abroad who has a lot of needs in the United States, or they could be coming here to work for a US employer full-time. The job offered must be a qualifying profession under the regulations. This is very strictly defined. There is a list of qualifying professions found at 8 CFR 214.6. So any job offered must fit within one of those positions listed. An engineer is included. This includes more specific engineers like biomedical or civil engineering. So engineers would fall into TNs, which is handy. At least a bachelor's degree is required, just like the H-1B program, and approvals are given out in 3-year increments. On the right, you'll see an example of a TN visa stamp. So one of the pros of the TN visas is that unlike most of your other visas where you have to apply at USCIS, Canadians can actually apply at a port of entry with CBP. And if they're approved, they get a visa stamp just like that on the right. And that serves as their proof of status. So Canadians are afforded a lot of special treatment under the program. Avoiding applying at USCIS is a big money and time saver. They can just prepare their documents and get a decision on the same day as their application. This is done both for initial and renewals. Just so everyone's on the same page, a port of entry is either a land border. So for instance, Montreal, right at the line of the US and Canada, is a land border. And any airport is also a port of entry. And CBP is an abbreviation for Customs and Border Protection. These are the individuals who you interact with after coming off of a foreign flight. They take your passport, your customs documentation, they might ask you a couple questions, but those are the officers that you speak to. Mexican nationals are not so lucky. They can apply at the consulates. That can be a little bit of a longer process, and an interview must be pre-scheduled in advance. However, they can also avoid applying at USCIS. Consulates right now with COVID-19 are kind of backed up, but in a pre-COVID world, applying at the consulate was much easier than applying at USCIS, so still some benefit. It's relatively inexpensive. It's only $56 if applying at the port of entry and $160 if applying with a consulate abroad. And there's no annual cap, so no lottery. Finally, there are a few cons. The TN visa is only for Canadian and Mexican nationals. So unfortunately, if you have any employees in mind who are not from Canada or Mexico, the TN visa is unfortunately not going to be an option. The position offered must fit within a list contained at 8 CFR 214.6, like I mentioned before. This really hampers our creativity, to be honest, as immigration attorneys. It's very much, while the TN visa functions very much like an H-1B, it has its very large differences. This is one of them. An H-1B, we could make an argument that any position qualifies as a specialty occupation as long as we can overcome a burden of showing that at least a bachelor's degree is required. Other than that, there's no restrictions. The TN visa, we must show that a bachelor's degree is required and it needs to fit within a very restrictive list. Further hampering our creativity is that in order to qualify, the applicant must show that he or she has at least a bachelor's degree in the field related to the occupation. So an applicant cannot apply for entry as an engineer under the TN visa if he or she only has a degree in history, because history is not related to engineering. Like I said, this sometimes hampers our creativity if we want to get creative and make an argument that a job offered fits within the list at 8 CFR. You know, for instance, I've had jobs come up where they might have certain like accounting or financial duties, and I try to fit them into the accountant category, which is also contained at that list. But unfortunately, the beneficiary does not have a degree in accounting or finance or economics. They have something in government or politics that's completely unrelated. So unfortunately, that kind of makes it harder. It is worth noting that the TN visa, like I said, while it functions very much like an H-1B, it is meant to be restrictive. It's not meant to be one of your broad catch-all, sort of like the H-1B. And these two requirements certainly help make it that restrictive. Finally, here's a comparison of all your non-immigrant visas that we discussed today. As Abby mentioned, I'll be handing out my slides at the end. You guys can review these. It kind of covers filing fees, timing, education, things of that sort. So let's move a discussion into immigrant visa. So I heard a few of you mention the green card process. So there are multiple different ways of obtaining an employment-based green card. However, we're only going to talk about one option, which is PERM. This is going to be the most frequent way that people have to go through the green card process. In fact, it's the default way of getting a green card. It's only if you meet certain exceptions that are very rare that you can avoid the PERM process. So nearly everyone who you speak to, anyone who you want to start a green card process for, this is going to be the way to do it. PERM stands for permanent, and it's an employer-sponsored program. It consists of 5 different steps. And overall, the PERM process is very long and tedious. It takes about 2 years start to finish, sometimes longer for someone to get a green card, which I'll discuss towards the end. Overall, the PERM process is really meant to protect U.S. workers. There's a lot of hurdles you have to jump through to show that you are not negatively affecting U.S. workers. So as a result, employers must show a couple things. The first, that they will pay at least a prevailing wage or minimum wage to a foreign worker. That the foreign worker is not going to be taking a job that a U.S. worker is qualified and willing to take. And that the foreign worker meets all the minimum educational and experiential requirements of the position. So it's worth noting that unlike any of the non-immigrant visas that we discussed that had minimum educational requirements, like the H-1B TN that required at least a bachelor's degree, the L1 and the O1, while they do not explicitly have educational minimum requirements, their requirements naturally kind of beg at least a bachelor's degree, if not higher. The PERM process is for anyone. All the way from cooks all the way up to medical scientists. It doesn't have to be for a professional position. There's no minimum educational requirements. And additionally, a PERM process could be started for someone who's outside the United States. So someone who's not even here in the United States could be the beneficiary of a PERM process, as long as that person understands that it might take a couple of years in order for them to permanently immigrate to the United States. So the first step is a prevailing wage determination. This is submitted to the Department of Labor. There is no fee for the application. And the application consists of a description of day-to-day job duties, minimum educational and experiential requirements, and any factors that affect pay, like supervisory duties or required travel. Unfortunately, there are restrictions that are atypical from traditional recruitment or promotional practices. For brevity, I'm not going to go into those, but certainly feel free to ask me in the Q&A. There are a lot of requirements the DOL has instituted in an effort to protect U.S. workers. And those restrictions, unfortunately, just do not usually blend very well with traditional recruitment practices. Additionally, you have the additional hurdle of showing that the employee actually meets the minimum requirements, which can be restrictive under the PERM process. So all those combined, I always make sure my employers know that while we can use your minimum requirements that you set forth in your last job posting, do not feel too attached to those, because usually going through the PERM process usually shakes those up. It's also worth noting that the minimum requirements that we set forth at this stage will follow us throughout the entire PERM process. So we can't say something in step 1 and then say something different at step 3. It always has to remain exactly the same. So I take a long time at the first step to make sure everyone is on the same page, everyone agrees, including the employer and the beneficiary's proposed supervisor, just to make sure that later on down the line, people aren't surprised by the minimum requirements. The Department of Labor takes about 4 to 6 months to certify the form and then returns it back to us with a minimum wage that must be paid to the foreign worker. The minimum wage is the prevailing wage. The offered wage can be higher. It can be at the prevailing wage. It just cannot be lower. The second step is a recruitment. So in an effort to protect U.S. workers, we must perform a test of the labor market. So this is pretending that there is actually an opening for that position and seeing if anyone responds. So we usually post job ads in local newspapers, job bank, employers' websites, job recruitment websites like Monster and Indeed. And any candidates who respond with a resume must be interviewed by you, the U.S. employer, to make sure that they in fact meet the minimum requirements of the position. If you determine that any of the individuals who respond are qualified and they are interested in taking the position and they are a U.S. worker, the perm process must stop, as otherwise your foreign worker would be taking the position from a U.S. worker, which isn't allowed under the perm process. The step 3 is a labor certification application. So if no qualified and able U.S. workers come forward during the recruitment stage, an application for labor certification can be filed with the DOL. And this application for labor certification isn't of itself an attestation that the U.S. employer was not able to find any qualified U.S. workers, which is why we cannot proceed with the process past step 2 if you find anyone. There's no fee for this form, but the form is incredibly lengthy. It details the job offered, including the job duties and minimum qualifications. As I said, this must match in step 1, the prevailing wage determination. Details about the recruitment, including the dates and where the ads were posted. Details about the beneficiary, including their current employment and qualifications for the position. In addition to the labor certification application, the employer must keep a recruitment report on file, which consists of a list of all the ads, where they were posted, when they were posted, a list of all the candidates who applied and why we disqualified them. And in addition to that, we must keep all of our proof of advertising, any resumes received, and any interview notes taken during interviews on file. The reason why is that the Department of Labor can audit the labor certification and request this documentation at a later date. So we are required legally to keep this on file, but the DOL does not necessarily ask for it. It's not submitted with the labor certification. They can ask for it in certain instances. DOL usually performs random audits on labor certifications. In an audit, they will most definitely request this documentation to make sure you adhere to the requirements of the perm process. The DOL takes 6 months to adjudicate the labor certification and longer if an audit is made. Sometimes with an audit, that can take up to a year. Once that labor certification application is approved, we move on to the immigrant visa application. This is where we file with USCIS, and this is also where the filing fees kick in. There is a fee of $700 to file an immigrant visa application. There's an additional premium processing option of about $2,500, same as your non-immigrant visa. And in this stage, we include the certified labor certification as proof that you met all of the requirements of the perm process. However, at this stage, USCIS rarely concerns itself with whether or not you filed the perm process accordingly. They usually leave that in the realm of the DOL. So at this stage, USCIS is really only determining 2 things: whether you, the employer, can pay the offered wage to the beneficiary, and that the beneficiary meets the minimum requirements as laid out in step 1, the prevailing wage application, and step 3, the labor certification application of the offered position. So this is where we submit diplomas, transcripts, educational evaluations, and past employment letters to confirm that the beneficiary in fact meets those requirements. Finally, we also submit taxes or financial documents of the employer to prove ability to pay. Next, and this is the final stage of the immigrant visa process, this is the adjustment of status or consular processing. So whether you apply for adjustment of status or consular processing is determined where you are. So if you apply for adjustment of status at USCIS, you are currently in the US in non-immigrant status. There is a $1,225 fee, and you apply at the consulates if the beneficiary is abroad. This is $445. At this stage, there is no concern about the other requirements. There's no concern about whether or not you followed the PERM program. There's no concern about whether or not the employee actually meets the minimum requirements, because all of that has already been predetermined. At this stage, the only concern is admissibility. So whether or not this employee qualifies for a green card. Admissibility in the immigrant context is going to look very much like it does in the non-immigrant context. We looked at various factors, including criminal history, prior immigration violations. This is also the point where we prove that any time that the US or that the employee has spent in the US has been proper, that they actually had a prior status and they properly maintained it, in order to show that any time that they spent inside the United States was legal and proper. Finally, there is also a concern of past or current membership in certain types of organizations, terrorists, communists, the Nazi government. Those are all questions that you'll find on the adjustment of status or consular applications. The reason why is we're making sure that people are not going to pose a public safety risk upon entering the United States. So some employees are able to apply for a green card with their immigrant visa application concurrently or at the same time. Others will need to wait. It's worth mentioning that if the beneficiary is abroad, the immigrant visa application will need to be wired to their consulate of their choice. So naturally, an approval from USCIS on the immigrant visa application has to come first. For someone who is in the United States and is applying for adjustment of status, depending on what country they were born in, they might be able to apply concurrently or at the same time. Others will need to wait. And the reason why is that there's a quota on the number of immigrant visas given out per year, per country, and per employment-based category. I know that's a lot. We'll get into the specifics in a minute. Each country has only a certain number of immigrant visas to give out per year, per employment-based preference categories, and those are hard stops. The employee is charged to their country of birth. So sometimes we'll have people who are born in India but have citizenship in Australia. Unfortunately, you are by default charged to your country of birth, not any countries of citizenship. And unfortunately, there's no country shopping either to try to get around long visa wait times. You're just naturally charged to your country of birth. There's no way around that. There are 4 employment-based preference categories ranging from first down to the 4th. First is the best, down to 4th, which is least preferable. The reason why is that more visas are given out in the first preference, down to subsequent lower amounts in subsequent categories, down to 4th, which receives the least. What employment-based preference category you fall into is determined by the minimum requirements of the offered position. So typically engineers would fall into either the 2nd or 3rd preference categories. So how do we know when someone is eligible to apply for an immigrant visa? Well, we have a visa bulletin that's issued every month by the Department of State, and that tracks who is currently eligible to apply for an immigrant visa. Everyone who goes through the green card process is assigned a priority date. This is the date that the labor certification was filed with the DOL on their behalf. And that date is used to track whether someone is eligible. So the visa bulletin is a list of countries it's a chart. So it has all the countries on the top, and on the side, it's going to have your employment-based preference categories. And in each column, there's going to have a date. Someone who is eligible or current on the visa bulletin is eligible to apply for an immigrant visa only when their priority date is prior or at the same date listed on the visa bulletin. So here's a visa bulletin for your reference. This is actually this month's visa bulletin. The Department of State is going to be coming out with a new one shortly at the end of November for December. But this is the current one right now. Just a few things I want to point out. Employees from China and India have very long wait times because traditionally they receive more applications, way more applications than they have immigrant visas to hand out. So if you look in India in particular and the second or third preference category, the second preference category lists December 1st of 2011. And the third preference category lists January 15th of 2012. This means that for an employee who's in the second preference category, they cannot apply for a green card unless they have a priority date that is at or before December 1st, 2011. That's a very long time. Traditionally, India is running about 8 to 10 years for a visa wait. China, you'll see, also has a similar concern, although much less so than India right now. So those are just a few things in mind. This is another reason why the H-1B is very handy for applying for a green card later on down the road, because you can apply past that 6-year cap as long as you started a green card, because it's going to be about an 8 to 10 wait before you have that green card in hand. So it's always great to make sure that their non-immigrant stay is kept valid and they can continuously maintain their H-1B while waiting for that green card. Finally, I just want to wrap up with a very brief discussion of legal fees. I'm sure you noticed that I didn't talk a whole lot about that, and there's a reason why. It's worth mentioning from the outset that the employer is fully responsible for filing fees and any legal costs, including costs of hiring an attorney. Additionally, any recruitment costs incurred during the perm process, like posting in newspapers, those can be rather costly, and those are the responsibility of the employer. There's no way of transferring these to the foreign national in any way. Sometimes people have tried to, have a certain amount taking out of the employee's biweekly paycheck to reimburse them. In no way, whether it's reimbursement or upfront costs, can the employer ever transfer these fees to the employee per USCIS and DOL regulations. So unfortunately, it's not really possible for me to provide a good estimate of legal fees. The reason why is that it really depends on the firm you go to. Some firms will offer you discounts if you provide a lot of business to them. Others charge fixed fee, others charge hourly. Some charge a yearly contract. So if you provide all their immigration work to them, they'll just provide like an annual amount that's not even based on the number of cases that you file. And generally, location also plays a role. If you go to a New Hampshire attorney, those are typically going to cost less than maybe one in downtown Boston. So the legal fees, they really span a great amount. I would estimate at least for an H-1B, at least $5,000 to $10,000 to support the process. But there are some relevant factors to consider. So the more documentation, there's a higher cost. So the O-1 will cost more than an H-1B because it requires more case analysis and more documentation. It generally takes more time to prepare as well. More time or attorney resources also means a higher cost. So perms will cost more than non-immigrant visas because perms take about 2 years. An H-1B, just leading up to filing, maybe takes a couple weeks, a month. So it's a lot less time, a lot less investment. Initial applications for status will cost more than extensions. The reason why is a lot of analysis and eligibility determinations go into initials. Extensions, sometimes depending if the job hasn't changed, can be just a copy and paste job from the last time, which saves time. And then time of year may impact fees. So H-1B caps may cost more because they're done during cap season, which is a time of higher demand. So now is a time for our question and answer period. I've left my contact information on the slide. I'm more than happy to stick around until 4:30 for questions or whenever the presentation ends. And if I don't have time to get to your question, always feel free to email me. Email is probably the best way. And I'm always happy to answer any questions that may come up.
Thank you, Ashley. That was wonderful. Does anybody have any questions?
I am back. My electricity came back.
Wonderful.
Wonderful.
So let's see. I see one. Oh.
Yeah, if anyone has any questions, feel free to speak up.
I have a question, Ashley.
Yeah.
Hi, nice to meet you. Thank you so much for your presentation. It was great. I actually went through an O visa status and it was really, really fun. And we ended up getting one, which was a long time ago. So that was very cool to listen to you talk about that, because I remember doing it and it was very, very interesting. One thing I wanted to ask was, we have a person that's waiting for a notification from the USCIS. I know you can't do anything about it. I know that, you know, it's been a real challenge. The person opted to go the route of, you know, ended up marrying a US citizen and coming to work for us, waiting for a visa via the marriage instead of an OPT. So their lawyer had advised them to go the direction of getting a work authorization via the marriage instead of the OPT, because they felt like it was going to be a conflict. So now they're just waiting, and we are waiting.
Right.
So I guess my question is, like, any wild ideas of like what the wait time is, or any way for us to like even know? I mean, is it, because right now it's just, we're just waiting.
Right. So there are a couple ways to kind of keep track. USCIS does have case processing times that they post online. They are not necessarily held to those case processing times. They're more of an estimate, but sometimes that provides a good idea of where they stand in terms of processing applications. So depending on where this person is in the family-based process, depending on what form's pending, you can check online, and it has you enter the service center where the application is currently processed, and it will give you an estimate of how long it takes. If you notice that that date is past, it's at least a month date past. So it does give a date of like, we're currently working on applications received on November 11th of 2021. If the date was October of 2021, it was at least a month behind. You can reach out to USCIS for something called a service request. It's essentially for an update, asking them to move quicker on the application or just kind of get an idea of what's going on. USCIS is not obligated to respond to those, unfortunately, but sometimes it's kind of luck of the draw. It can speed up the process. And then finally, just in terms of work authorization on your end, I know that you're waiting. If the person has an adjustment of status application pending, they can get a work authorization while they're waiting for that adjustment of status to be approved. It takes about a year for an adjustment of status to be fully adjudicated, so they do hand out work authorization cards if applied for during that year. So that might also be an option to kind of speed up in terms of getting that person there to you more quickly.
It seems like we should probably be reaching back out to that person's lawyer.
Yes, their lawyer will know more about what date things were filed and where USCIS stands in terms of current processing times. One thing I forgot to mention as well is there's a receipt number on every single application up at the top right-hand corner. They also have a page where you can enter that receipt number to receive in-time updates on the application. So sometimes those are not really updated in time, and frequently people will log in and it will just say case received because they're still processing it. So it usually jumps from like case received to case approved, but sometimes that can give a good idea of where USCIS is at in the process.
Awesome, that was so helpful. Thank you. That's great. Yep.
Great. Does anybody else have a question? No? All right. Well, Ashley, thank you so much. This was really, really, really informative.
Of course. I'm glad. I hope it was helpful. Like I said during my presentation, my slides will be made available. I'm going to be sending Abby an email later on today, sending out my PowerPoint. My contact information is here. Always feel free to reach out to me with any questions or concerns at email. Email is probably best preferable. But I'm always at your access if anything comes up.
Great. Thank you so much. Thanks
Thank
everybody
you.
for participating.
Thank you.
It was such a pleasure. Have a good night, everyone.
Good night.
Thank you.
Night.